Dear conference, distinguished colleagues, thank you very much for inviting me for this very important and fruitful conference. Luckily or unluckily, the topic of my presentation is the same as that of Professor Orezsiak's, but the roles and pathways of constitutional courts in the field of asylum law and policy, but my point of view is a bit different, as you will see. Last year I was participating in the Hungarian Constitutional Court's European Constitutional Communication Network project. It's a very interesting initiative, to be honest. The Hungarian Constitutional Court made a database about the most important decisions of mainly of the Eastern and Central European Constitutional Courts, and translated these decisions to English to make them more accessible. And the project was to do a comparative legal research using this database. The construction of this database is still ongoing, so currently there are around 600 or 700 decisions available there. And I was checking these decisions, looking for asylum law cases, but for my surprise I couldn't find these kind of decisions. Naturally, I thought that this is the problem of the database itself, because the topic is, as we've seen, quite relevant in this region. So one would think that because there are quite a lot of asylum challenges here, there should be at least some constitutional court decisions too. So I started to look around in the literature, in other databases and news and so on. And it was quite a challenge, to be honest, to find these decisions, and not only because of the given language barriers. So turning to the main point of this presentation, my research focused on the question whether, while the current European human rights protection system is based on a multi-level protection of human rights, so whether there is a role for the constitutional courts in the asylum field in this multi-level system. It is clear that the national courts are the ones that decide on the substantive and procedural issues that arise, and ultimately it is the European Court of Human Rights that sets human rights standards for the Council of European Member States. However, the question is where the constitutional courts fit into this system. My first point was that, as we have heard yesterday too, migration is in fact closely linked to state sovereignty, especially after the rise of nation states. The scope for discretionary action by a state in relation to its population in respect of aliens is quite broad, as we know. In principle, both EU law and the European Convention on Human Rights recognize the sovereign right of states to border control activities, to control the entry and residence on their territory. At the same time, however, national specificities in relation to immigration are becoming increasingly unraveled, and more barriers are emerging that limit the scope of state action. We all know that for a very long time the right of asylum was closely linked to the church and various holy places, providing protection against excessive criminal state criminal power. Then, with the decline of ecclesiastic power and the spread of concept of state sovereignty and the need for justice, the institution of diplomatic asylum in the modern sense was created, and by the 20th century, through the institution of territorial asylum, the state was already providing protection on its own territory to those persecuted by another state. Let us add that in the 20th century, we have seen examples of two major regimes in the Western world in terms of their attitude to immigration. Prior to the Second World War, there were many examples of migration being tightly controlled and humanitarian considerations being taken poorly into account. But in contrast, after the Second World War, and particularly from the 1960s onwards, there was a growing emphasis on drawing lessons from the experience of the war. One prime example was the 1951 Geneva Refugee Convention, also growing influence of social movements, including anti-colonialism, New Left, racial identity, feminism, and so on. From this period onwards, the granting of asylum was removed from the absolute state discretion of power and assumed as an international legal obligation by states, thus making it legally binding decision-making process, reducing the former state discretion. Territorial asylum is now much more a right of the individual and may even be constitutionally protected, and from the state's perspective includes the following state actions: to admit the person to its territory, to allow the person to remain, to refrain from expelling or extraditing the person, and to refrain from persecuting, punishing, or otherwise restricting the person's freedom. Although the right to asylum has traditionally been seen as a right of the state rather than of the individual, it now comprises the right of the state to grant asylum, the right of the individual to seek asylum, and the right of the individual to be granted asylum. Both universality and the treatment of migration within a purely legal framework created tensions in the sense of how the ideal of human rights and immigration control as a crucial and fundamental aspect of state sovereignty balance each other. One of the functions that underline the importance of a constitutional court is the protection of this sovereignty. Sovereignty is created, is central to the creation of the state and its potential for transformation, and therefore also plays a crucial role in realization of human rights that's given. However, the relationship between sovereignty and human rights is two-sided. Some views that human rights, or more importantly, their universalism, erode sovereignty in the classical sense that the state acts at its discretion within its own territory, and others hold that because sovereignty is relatively socially constructed, historically specific and changeable, it is better understood as being transformed by human rights. This dual face of sovereignty is clearly visible in migration issues. There is both the notion of a sovereignty as the ultimate decision, sovereign as the ultimate decision maker, and the sovereign as the institutional guarantor of human rights, which may conflict. As an institution, the constitutional courts are the guardians of the country's constitution, and thus the framework and basis of the state's functioning and legal system, and thus contribute to protection of the sovereign functioning. However, there is also an aspect to the question of whether the constitutional courts can be used at all, or whether they are used, or whether asylum and migration issues pass unnoticed by the constitutional courts. On the other hand, in some of the problems that arise, it is also questionable whether there is a basis for providing access to the court procedures at all, and if access to the judicial route is difficult, as we can see, then of course the constitutional complaint procedure too, which should be based on the judicial decisions. In addition, if the persons concerned are themselves reluctant, we can see in this region this too, as they have no intention of remaining in the territory of the country concerned and therefore do not wish to avail themselves of the protection and procedures available there, then again we can see that the latent problems are not brought to the attention of the courts and ultimately to the constitutional court either. The countries of this region before the transition and the change of regime were still refugee-producing states, and as such did not have to face international migration process and resulting gradually increasing cultural diversity that characterized the Western European states. As a result, starting from 2015 or 2014, they were suddenly saddled with the responsibility for everything, and they were in the focus of repeated human rights criticism. Where does the Constitutional Court stand in this complex situation? We have heard yesterday one type of methodology to examine this question. I have a different point of view. I focused on the protection of individual rights and the law development activity of the Constitutional Courts. First, we need to emphasize, as Professor Szilágyi mentioned yesterday, that English is not the official language of any of these countries here, but it's more or less a common language. However, what we see is that the constitutional courts of this region rarely publicize their asylum-related decisions in English, if there is any. And of course, the most important decisions are available, but this is just a small part of the big picture, so it's not enough. So, from this linguistically somewhat narrowed point of view, what we can see is that constitutional courts of Poland, Bulgaria, and Romania have had virtually no influence on the interpretation of the constitutional institution of asylum during the last 8 years. In case of Poland, where the constitution itself excludes asylum complaints from the constitutional complaint procedure, that was quite extraordinary, to be honest. This maybe can be seen as an evidence that the Polish legislature treats the right to asylum more like sovereign right of the state. In case of Bulgaria, that was in language sense the most difficult to research. So Bulgaria's constitution enshrines the right to asylum by reference to the International Convention. Bulgaria joined the Geneva Convention in 1993, but by the end of the 90s, asylum law was not regulated by a legal act, being governed instead by regulations and decrees. Development of legislation and institutions only took place in the 2000s, only to be seriously tightened up in the wake of the migration crisis of the recent years. The pattern is similar to the other states in the region, but Bulgaria does not have a constitutional, or at least I couldn't find a constitutional court jurisprudence, legal practice in asylum matters. Romania also constitutionalized the right to asylum and the requirements for return by reference to the International Convention. Over the years, Romania has also evolved from a transit country to a destination country too, and there were examples of the presence of the Constitutional Court in this process. There is a decision from 2001, for example, where the Constitutional Court stated that some provisions of government ordinance on the status of regime of refugees do not ensure the effective protection of the rights of applicants for refugee status. The problem was about exercising the right of appeal, which wasn't effective at that time. There was also a decision about effective right to access to a court, but according to current criticism, the provision of a multi-pronged complaint mechanism in Romania, the use of the mechanisms by the injured third country nationals, minimal and ineffective, because practical and legal barriers in accessing the complaint mechanisms have increased since 2017. Thus, there are still some issues that could be subject to constitutional review, but it can be seen that in recent years, no such cases have been brought before the Constitutional Court. I consider the Hungarian Constitutional Court as one of in the state of kind of in a transition. because Article 14 of the fundamental law regulates the right of asylum, which originally basically adopted the concept from the Geneva Convention, but without the reference to the Convention, and enshrined the principle of non-refoulement too. But later it also raised to a constitutional level the concept of country of first asylum and state third country. Hungary, as an external border of the European Union, has been facing a significant wave of migration since 2015, but it is an interesting contrast that despite these asylum cases in the strict sense are almost non-existent in the practice of the Constitutional Court. The issue has arisen more unilaterally as a question of sovereignty, identity, national culture, and most importantly regarding the competencies of the European Union. These were all linked some way or another some asylum law and policy questions, but they did not provide answers to everyday issues that affect the asylum scene, such as access to the territory, the pushback phenomenon, provision of procedural guarantees, or even the effectiveness of legal remedies and the conflict of these with state sovereignty. There is a wide range of instruments available, but their application does not go as far as the remedy of specific violations of rights. Questions related to the right of asylum tend to appear at an abstract level, and the Constitutional Court has typically avoided a detailed interpretation of the constitutional content of asylum law. We had a case pending for years, actually, and this was decided just last week about the redistribution of the refugees from 2016, but the court dismissed the proceedings, and by the way, the decision has gone unnoticed until now. It's available on the site of the Constitutional Court. There is only one decision that blunted the edge of the restriction on the right to asylum, where the court deduced from the plain meaning of the text that asylum seekers arriving through a quasi-safe country have also a fundamental right to have their claims examined. Contrary to the mentioned court, the Croatian Constitutional Court seems to be a bit different, because it is evident that not only is there a pathway to subjective legal protection of asylum issues by the Constitutional Court, but that this pathway is also used from time to time by the persons concerned, and the Constitutional Court conducts a substantive examination. In the so-called Huszánykál 1 case, the applicants detained in the reception center complained of having been denied access to a lawyer, and that the conditions in the reception center had not met the requirements of respect for human dignity. And the Constitutional Court had verified relevant evaluation reports before deciding on the case. Similarly, in the oral case, the Constitutional Court found that the fact of having been granted an asylum, and now I just followed a good example of Professor Novak from yesterday, because battery of my laptop just died. Thank you very much. So, in her case, the asylum. So, the fact of having been granted an asylum in the Swiss Confederation prevents the applicant's extradition to the Turkish Republic, Turkey. There is a joint case from 2019 concerning Iraqi national. The Croatian Constitutional Court examined the case through the scope of non-refoulement, examined the general situation in Iraq, the applicant's allegations as to the specific risk he would face if deported, and in the end the possibility of removal of the risk by internal relocation. Even though the applicant's complaints were rejected as unfounded, the Constitutional Court has nevertheless decided on the applicant's asylum application on the merits by applying the principle of ex nunc evaluation, providing him with a fully effective legal remedy. From 2018, this is the last example, the Constitutional Court held that Croatia had violated the human rights of the applicants and exposed them to the risk of torture and ill treatment. The ruling concerns the rights of a family of a 6-year-old girl from Afghanistan. This is a quite well-known case, whose death was caused by illegal expulsion. And the Constitutional Court has taken the view that in assessing a country as safe, it is not enough to rely on the normative framework and the numbers of approved asylum applications, but that it is obligatory to take into account relevant reports by bodies concerned with the protection of refugees and NGOs in order to determine the real treatment of persons. And as far as I know, there is also an ongoing case from last year, about more than 2 years, without effective investigation of brutal pushback. So, to summarize everything, the refugee crisis following the Arabic Spring has drawn attention to the asylum practices of the countries of this region that are the external borders of the EU. Countries that had been refugee countries before the transition became gradually potential asylum providing countries unprepared for the sudden crisis. This is not a criticism on myself, on my side, because switching from one day to another from a few thousand cases per year to a few thousand cases per day, it's kind of like unable situation. But what I try to answer is the question whether from this period onwards, national constitutional courts had any role, if they had, in developing the law, and whether they had any significance for the content of the constitutional institution of asylum. One of the findings of the research in this area was that the international legal literature has basically neglected this issue, but so has the national literature too, as far as can be assigned, accessed without knowledge of the given language, although I was checking in Romanian, Croatian, and so on. Although the right to asylum appears in the Catalogue of Fundamental Rights, if my research methodology is correct, it can be stated that of the triad of national courts, constitutional courts, and international courts in this area, it is the constitutional court that has lost its significance, its relevance, whereas the issues that could potentially arise could be interpreted in a constitutional dimension, as the Croatian example showed. Thank you very much.